an appeal in the matter of Abdikadir and London Borough of Ealing?
Yes, Mr. Van Heegen. I can tell you that we have read the Saggerson arguments, we have read the decision of the judge, we have read the review decision of the local authority, so we know what the case is about. We have an application by Ealing to rely on their temporary accommodation acquisitions policy. Is there any objection to that?
Yes, there is, and we set that out in paragraph 8A of our skeleton. I don't know if any opportunity to see that, but that's the basis of our opposition.
What is the objection?
Well, we don't really know where it's going. I mean, it wasn't relied on by the review officer, it wasn't relied upon below, it wasn't in the Respondent's Notice. There are two very brief mentions of it in the Respondent's skeleton.
Well, it wasn't in the review decision because it wasn't raised in the review.
No, it wasn't. I mean, it wasn't relied on by the reviewer.
Or by your client's solicitors.
That's right.
So they must be able to defend themselves, surely, if you're raising it now, which, according to the case law, you're entitled to do.
We're not raising it now. We don't seek to rely on the policy. They're seeking to rely on the policy, and from the two brief mentions in their skeleton, it's not awfully clear to us on what basis they are seeking to rely on the policy.
Well, you're saying they didn't look hard enough to comply with section 2081.
Exactly.
And they're saying, well, this is what we do.
Well, if that's what they're saying. I mean, they don't spell that out in the skeleton, but I can see my lord's point.
Yeah. All right. Well, I think we're going to admit it.
Very well.
And I think what we would like to do, if this doesn't inconvenience you, is to hear from you both on section 2082, the duty to notify, both sides, including the point taken in the Respondent's Notice, and then we'll move on to other ground.
So, my lords, my lady, I obviously appear for the appellant with Miss Lovegrove, and it's the speech appellant, Miss Cullen, for the respondents. Now, the respondents, in their approach to the appeal, really take 3 points in relation to our ground one. So I'm going to respond to that using those 3 points.
Yes.
And the 3 points are, firstly, the point about when does the notification duty apply.
Yeah.
So this is the point in their respondent's notice, is that it only applies if the applicant accepts the accommodation offered. Secondly, they take a point on jurisdiction. And thirdly, they take a point on relief.
On?
Relief.
Yeah.
So does it make any difference point? So I'm going to divide my submissions into those 3. And when I've dealt with those 3, I also want to look at the relevance generally of the notification duty, because in my submission that informs some of the other points. So if I can turn firstly to the point about timing, or what the respondents call the trigger. And so the difference between us here is that the respondents say that the duty to notify only applies where the applicant accepts the offer of accommodation.
Yeah.
And we say, no, it applies at the point and within 14 days of the accommodation becoming available, and becoming available does not depend on acceptance.
Or you say available means that they could move in if they chose to.
Exactly.
Right, that's a very short point.
Right. I prepared rather more to say on that. But I'm in my Lord's hands. I can develop that.
Well, by all means develop it, but I mean, that's the point.
That's the short point, yes. I mean, the question is who's right. I mean, that's probably
I think that's why we're here.
Yeah. So can I look at the section, first of all, which is in the authorities, page 67.
Sorry, I missed the page.
67.
67.
So we can skip over subsection 1 for now, because that's ground 2, and that's what we'll come back to. So subsection 2 is the notification duty. So if they secure that accommodation is available, they shall give notice. Subsection 3 sets out the requirements of the notice, and we make 2 points in relation to that. One is, it's not an onerous duty. It's simply to tell the notified authority about the offer. And it's the sort of thing local authorities are used to doing when they make local connection referrals. And secondly, we agree with the respondent's point that actually, if one looks at the section, there's no obligation on the notified authority to do anything in response.
And 3D says that you must notify of the date on which the accommodation was made available.
Yes. And then subsection 4 is the timing point. So it must be given before the end of the period of 14 days, beginning with the day on which the accommodation wasn't made available to the applicant. So the issue is, what does that mean? And we have identified 8 reasons, and I'll deal with them very briefly, but 8 reasons why the respondent's interpretation about acceptance is wrong. The first point is, there is nothing in the section about acceptance. The duty is not conditional upon acceptance. The wording used is, as my Lord's correctly identifies, and my lady, was made available. Secondly, we submit that the wording in subsection 4 was made available indicates that it's a unilateral act of the authority. It's not something that in any way is dependent upon the reaction of the applicant. Thirdly, this is points 3, 4 and 5, we say that their interpretation is inconsistent with the use of the words was made available in other parts of Part 7. So point 3, we rely on section 193, and if I could just ask the court to go to 193, which is on page 22. So this is the full housing duty, and if one turns over to page 23, it's subsection 2, that sets out the nature of the duty. They shall secure that accommodation is available for occupation by the applicant. Again, it's a unilateral act, it's not dependent upon whether the applicant accepts. If the respondents are right, and that the applicant has to accept for the accommodation to be available, the authority can't comply with subsection 2 unless the applicant accepts. And in my submission, that's not how the section works. And while we're on section 193, if I could look at 7F, which is on page 25. Seven F deals with not the situation in our case, which was an offer of a non-secure temporary accommodation, but it deals with final offers under Part 6 and private rented sector offers. And what 7F says is that the local authority can't make those unless they're satisfied the accommodation is suitable for the applicant. And in my submission, what subsection 7F is doing is saying there's a process whereby the local authority examine whether accommodation is suitable, and then having satisfied themselves as to that, they make the offer. And in order to be able to satisfy themselves as to that, we say one of the important elements in that is you notify the other authority, because you might get information back which informs your view as to suitability. So it's important to do that as soon as possible.
Sorry, I'm not sure I quite followed that. You say section 7F requires the local authority to satisfy itself that the accommodation is suitable before making an offer. So at the time when the local authority is carrying out that investigation, the accommodation is not yet available.
No, I'm
Is
not
that
sure that's
right?
necessarily right. We would say that they would identify the accommodation.
Yes.
And that accommodation would be the accommodation that is available. And then they look at whether or not it's suitable, and then they would offer it.
Well, they haven't secured that it's available.
Well, they might have done, and very often they would. There's no point looking at the suitability of accommodation unless you know that's the accommodation you're then going to offer.
So,
Because it's available to offer.
Yes.
so on your interpretation, the duty arises, could arise, long before any offer is made to the applicant.
It could, because the accommodation could become available before it's offered. It doesn't necessarily become available only at the offer stage.
So it would depend entirely on the actual circumstances, the actual factual situation about whether a flat or a house was empty and available, and discussions have been had with the housing association, etc.
Exactly. But certainly at the latest, it would be available at the time of the offer, because the point I'll develop is you can't offer something that's not available. Point 4 is in relation to section 191. Section 191 is at page 19. And this is the section that deals with when an applicant becomes homeless intentionally. I'm just looking at subsection 1, which sets out the definition. And what subsection 1 says is that a person becomes homeless intentionally if they cease to occupy accommodation which is available for his occupation. And where this often comes into play is that an offer is made to an applicant says, no, I'm refusing that offer, and then the applicant is considered to be homeless intentionally because they haven't accepted the accommodation that's made available to them. If my learned friends are right, the applicant is entitled to resist the accusation of being homeless intentionally by saying, well, it wasn't available to me, I didn't accept it, so it was never available, so I'm not homeless intentionally by refusing it. Point 5, and this is the last of the sections in part 7, I want to look at section 175, which is at page 8.
Sorry, section 1.
175,
Yep.
page 8.
Yes.
I want to look at subsection 1, which says that a person is homeless if he has no accommodation available for his occupation. My short submission here is, if the accommodation is not available when it's offered, then the applicant continues to be homeless. I mean, there's simply no compliance with part 7. And the applicant could refuse to accept on the respondent's arguments and say, well, it's not available to me because I haven't accepted, so I'm still homeless. Next, I want to look at 2 cases, Nikoleva and El-Kundi. So, point 6 is El-Kundi. No, Nikoleva. Nikoleva is in the authorities at page 351. And the relevant bit is on page 365, which is paragraphs 46 and 47. One of the issues in this case is whether accommodation had to be available to be offered, whether there had to be an identifiable unit of accommodation. And the court said yes. And at paragraph 46, letter B, it said, in order to be an offer of accommodation, it seems to me that it must be made by reference to an actual property which the applicant can occupy. Otherwise, it's not an offer, it's merely abstract. And then at 47, the court goes on to look at, in particular, subsection 7F, which we've already looked at.
Yeah. It's a slightly different point, but anyway, you rely on which the applicant can occupy.
Yes.
Yeah.
I say this is authoritative proposition that the accommodation has to be available and identified at the time of the offer. It doesn't depend on what the applicant might do in the future. It's not an offer if it's not available. Point 7 is El Kundi. And the relevant bit of El Kundi is on pages 437 to 439 of the authorities bundle. It's paragraph 77 and then paragraph 81. And the short point here is that the Court of Appeal in this case have recently held that the 1932 duty to secure accommodations available is an immediate duty.
Yeah.
So you can't, in my submission, it flows from that you can't comply with it if you're offering accommodation that's not available because the availability of the accommodation depends on the applicant's acceptance of that accommodation. And then the last point we make in relation to this is we rely on Chapter 16 of the Code, which is in the authorities bundle starting at page 75. I'm not going to go through it, but it's a chapter entitled Securing Accommodation.
Sorry, what page?
Page 75.
Yeah.
And we rely on this chapter because although it's about all the different ways in which the authority can secure accommodation is available, and nowhere in this chapter is there any mention of acceptance by the applicant or an act of the applicant being determinative of availability. It is a unilateral act by the authority. And if the applicant doesn't play along with it, then that leads to the discharge of the duty, but it doesn't affect the availability of the accommodation. And those are our submissions on the first point,
Yeah.
the timing point. And that takes me to the jurisdiction point. And in relation to that, it's important to understand what the challenge is. So the challenge is not just to the non-notification. What this challenge is about is to the decision on suitability by the respondents in the absence of a notification without taking account of the fact that they haven't notified and in circumstances where that notification might have revealed information that was relevant to suitability. We can't put it any more highly than that because in the absence of a notification, you just don't know what information would have turned up. But we say that when considering suitability, if you don't notify, that's got to be relevant. So you can't make a suitability decision when you've unilaterally deprived yourself of the potential of obtaining relevant information about suitability. So this is very much a challenge.
So just a minute, let me just try and follow that one through. If the conditions in section 1935 are satisfied, the housing duty ceases.
Yes.
That may be within the 14-day window within which notification should be given under section 2082, depending on facts.
Yeah.
If those conditions in section 1935 are satisfied and the local authority decides that the housing duty has come to an end, are you saying that what appears to be a lawful decision at the time it was made is retrospectively invalidated by a failure to comply with section 2082? That, I think, is where your argument leads. And I find it a difficult proposition, if I may say so.
So the review decision must look at the facts and the law at the time of the review.
No, not in the case of a refusal. I think it's O'Mahony in Westminster,
Yeah,
which says you look at the facts at the date of the decision that the housing duty has come to an end. It may be different in the case of an applicant who accepts the offer and then asks for a suitability review, but we're dealing with a refusal. My understanding is that you look at the facts at the date of the refusal. Oh, sorry, the date when the housing authority decides the duty has ceased.
Yeah, the law's not 100% clear on that, whether you look at the date of the offer or the date when the applicant refuses. So I think Omar Westminster talks about date of the offer. And if the duty to notify is only triggered at the date of the offer, then you couldn't possibly, at the time of the offer, have complied with the duty to notify. But although one looks at the circumstances at that time, one takes into account facts which were known or could have been discoverable at that time. So my submission, it is permissible subsequently to argue.
So there's no breach, or not necessarily a breach of section 2082 at the time of the refusal.
Oh, I agree with that, yes.
So if there is no breach at the time of the refusal, with a consequence that the housing authority decides the duty has ceased, are you saying that the subsequent failure to comply with section 208 retrospectively invalidates that decision? That's what I'm asking.
Yeah, it's a very good question.
So because following that through, you would say, I think, that must be right. Lord Justice Lewison, that analysis must be right because the authority could not be satisfied that the accommodation was suitable under 1935 if they hadn't served the other local authority, because they haven't got, you would say, the complete picture of suitability upon which to have made their decision. So it must. Does that follow?
I think that would be our answer, is that superficially it looks like it's suitable, but if
they fail to notify, you would say there is incomplete evidence as to suitability.
Exactly.
And therefore, they're not within 5A.
Yeah.
Because they can't successfully assert that the property is suitable.
Exactly. You'd still have to notify within the 14-day window, and that might turn up information which might then reveal that, in fact, although you thought it was suitable, it wasn't suitable.
So you'd say that it's a staged process, that they have to notify. You may have get a refusal in the meantime of the property, so look at the property, but 5A doesn't actually bite until you've complied with that.
Yes.
But given that they don't have to respond,
Yeah.
that's where I'm struggling.
No, well, in that scenario, I mean, we quite accept that there may well be there may be a large number of cases in which, in the end, it doesn't matter. But the duty is nevertheless to notify, and if they don't respond, or they do respond but they don't have anything to say that's relevant to suitability, then your suitability decision was right.
But the local authority, the housing authority, is sort of in the ether then, aren't they? Because you're saying if they fail to send the notice, then they haven't completed the suitability assessment. Therefore, even though they the applicant has refused the property, they haven't ceased to be subject to the duty because they haven't served the notice. Forever?
Well, no, because they could then serve the notice and get rid of the breach of section 208 subsection 2, and then either they get something back which they take into account.
They're allowed to do that ex post facto 3 months later, 6 months later? Or if they fail to do it within 14 days, are they left forever unable to show that a particular applicant is intentionally aimless?
So they can comply with it after 14 days, and that would prima facie be a breach of the section. But in our submission, what the 14 days is trying to do is get information about suitability at the time of the offer.
No, with respect, it's not doing anything of the sort. It's notifying the receiving authority that they are about to receive an applicant and their family who may make a call on their public services. That's what it's for.
Well,
it's not about extracting information from the receiving authority. It's providing the receiving authority with information so that, you know, there may be a change of school, or there may be children's services involved, or any of the different things that local authorities provide. That's why it's there. At least that's what the cases say.
Well, I'm going to come on to this point when I look at the relevance of it, but we say it's there for 3 reasons. We say it's there in order to obtain information about suitability, and whether or not there's schools that are available, and whether services can be provided by the notified authority and so on, go to suitability. Secondly, it's there to provide a transition from children's services in one authority to children's services in the other authority. And thirdly, we accept the respondent's suggestion that it might also play a useful role in local connection, so that the notified authority know that someone's coming into their area, so that if the applicant then applies to the notified authority's area, the notified authority are able to say, well, hang on, you arrived here within, it's 5 years at the moment, and therefore you have to go back and make your homelessness application to the area you came from originally. So we submit that it's got a variety of roles to play, and one of those is relevant to suitability, and I hope to make that good when we look at chapter 17 of the code. It's not just there to provide a transition from children's services. But even if it is, those issues are still relevant to suitability.
And on your suitability argument, just taking up from what my LadyJustice King said, what happens then if there is no reply? You've notified, but there's no reply. Does that affect whether the suitability criterion has been satisfied and whether the duty is fulfilled or not?
Well, then at that point, the authority has all the information that it could have on suitability. It's not missing out on anything.
But how does it know? How long does it give before for a reply?
Yeah.
There's nothing, is there?
No, there's nothing. And indeed, there's no obligation to reply. I mean,
But doesn't the fact that there's no... Sorry, I didn't mean to cut across.
No.
Worst sort of judge, please.
There's no... the respondents say that, and that's it. There's no obligation to reply. And when we accept that, there's no obligation to reply. There's no time frame for replying. So all one can say is whether they ought to be given a reasonable time to respond, and it all depends on the facts. But but generally a review is requested, and there's 8 weeks for doing the review. I mean, if they haven't responded by the time of the review, I think it can safely be said that they've got nothing helpful to say.
But isn't the fact that there is no obligation to reply, doesn't that undercut your suitability argument and simply reinforce the terms of the section as highlighted by my Lord Justice Lewison a moment ago? That it's simply about providing information, it's notification. It's not a reciprocal thing.
Well, when we look at the code, we'll see that the code does suggest that there's liaison between the authorities. And although there's no duty to respond on the notified authority, the code suggests that they do respond if they've got useful information.
The code doesn't, that part of the code doesn't refer to section 208 though.
No.
It's just a general piece of advice, perfectly sensible advice.
Yeah.
Can I ask you something else? If an applicant has refused an offer, What is the point of the notification?
I'm going to come on to that point as well. Can I come on to that point?
Yes, by all means.
I'm grateful. I think I probably dealt with the issue of jurisdiction. I mean, I do accept that if one was simply challenging the non-notification, i.e. one simply saying breach of section 208 subsection 2, then you probably have to bring a judicial review because it doesn't come within the scope of the...
Yeah, now you say it vitiates the decision under section 1935.
Yeah. And if I'm right about that, there's no jurisdiction problem.
Yeah.
And we have put the case of James and Hartsmere in the...
Yes.
Okay, so moving on to the issue of relief, and then I'm going to deal with the other points. On relief, I think, talking to my own friends outside, that we're agreed that the relevant authority is the Ali case, with Ali and Newham, which is at page 136 of the authorities, and it is an inevitability test. And one gets that from paragraphs 13 and 21 of Ali, which are on pages 142 and 144.
Sorry, tell me that paragraph again, please.
So 13 and 21.
Thank you. When I first read the Respondent Saggerson argument, I thought they were going to be arguing that it isn't an inevitability test, it's a highly likely test, which is why I handed up the case of Geese this morning, because paragraph 71 of that.
Well, this is not a judicial review.
Exactly. So in Geese, the Court of Appeal say it's not a judicial review, we don't think it's a highly likely test.
Yeah.
But it looks like that's not an issue between us. The respondents are happy to argue the appeal on the basis it's an inevitability test. And so the question then becomes, well, would the decision inevitably have been the same even if there was a notification? And in my submission, the answer to that is no. The burden is on the respondents to show that it inevitably would have been the same. And they can't show that in the absence of a notification. Because they can't prove a negative. They can't show that the notified authority wouldn't have responded to the notification. And if I could come back to the point earlier about what about a late notification?
Sorry, just hold on a minute. I'm not sure I quite follow this one. I think you agreed, I think, that you look at facts as they were at the date the local authority decided the duty had come to an end.
Well, the case law on that is that the discovery of subsequent facts can shed a light on what the previous facts were.
Yes.
Yeah.
So at that date, there might or might not have been a breach of 2082, depending on when the window starts, the window opens. If there had not been a breach of 2082 at that time, then why would the decision not inevitably have been the same? Because there simply was no breach.
Yeah. No, yeah. No, I agree with that proposition. I mean, this case is about if there is a breach. And
if there is a breach.
Yeah, if there isn't a breach.
So if there was a breach and the local authority should have notified under 2082 before your client refused the offer, I suppose, perhaps even before they made it, maybe your case, then that offer might have elicited a response from Hillingdon, and that response might have said something unfavourable about the housing association
Or the property.
or the property, which might have led Ealing to a different decision.
I can't put it any more highly than that.
Yeah.
It's a matter of speculation, but it shows why the respondents can't satisfy the inevitability test, because they can't show with any certainty And then just going back to the point made earlier about, well, what about a late notification? The problem with a late notification is what one's trying to do is establish the facts, either at the date of the offer, see Omar and Westminster, or at the date of refusal, I think it's Timor and Hackney, I think there's a slight conflict between the two. The problem with a late notification is you're going to get information probably coming back about the circumstances at the time of the notification. And if it's many months after, then the information you're getting back is useless, because it doesn't relate back to when you needed the information, which is at the time of the offer.
Yeah.
Unless, of course, with your late notification, you say to the notified authority, actually, what I want you to do is provide us with the information you would have provided to us if we had notified you properly back at the time of the offer. But a late notification is therefore generally going to be pretty useless, because you can't turn back time. And then one final point in relation to this is that if the situation depends upon the outcome, then 208 subsection 2 is unworkable. I mean, section 208 subsection 2 is a blanket. You've got to notify in all cases.
When you say on the outcome, you mean on whether the offer is accepted or not?
No, whether information comes back that's relevant to suitability.
Oh, I see.
So you can't retrospectively justify your non-notification by reference to outcome. It's not permissible for an authority to say, well, I didn't have to notify in this case, because if I had notified, I wouldn't have got any information back.
Yeah.
And then, lastly now on ground one, I want to deal with the relevance point. So as I said earlier, our submission is relevant to three things: suitability, children's services provision, and thirdly, local connection. So if I can deal with suitability first. This is the chapter 17 of the code. So chapter 17 of the code, the relevant paragraph is 17.22 at page 88. If I could just invite the court just to read 17.22 at page 88.
Yeah.
So I accept my Lord's point that this isn't in the bit about notification, which comes later at 17.59, 17.60, in an earlier bit. But what it says is that the Secretary of State recommends the authority to liaise, and obviously a perfect way of liaising is pursuant to notification. It obviously makes sense that the notified authority is going to have more and better knowledge of a property that's being offered in their area and of the landlord who's responsible for that property than the authority that's placing. So they will have information relevant to suitability, and the notification in my submission is an effective way of triggering the provision of that information.
Yes.
And suitability is relevant, not just to the authority, but also to the applicant. So in terms of the authority shouldn't be making an offer of something unless they're satisfied it's suitable. We looked at subsection 7F. Section 206 is also relevant in this regard. That deals with the ways in which an authority can comply with their Part 7 duties. And it's to be found in the authorities bundle at page 66.
60.
66. And it's subsection 1. So there are 3 ways in which an authority can discharge their Part 7 functions. Firstly, they secure that suitable accommodation is available, or they get suitable accommodation from someone else, or they give advice and assistance so that suitable accommodation can be obtained from another person. But it's all about suitable accommodation. So the authority have to be satisfied the accommodation is suitable in order for it to be good discharge accommodation. And for the purposes of a private rented sector offer or a Part 6 offer, as a final offer, they have to be satisfied before the offer is made. And it cuts both ways. So they may receive information about the property or the landlord as to why it's not suitable. But also they might receive information about the applicant as to why they shouldn't go to that area. And again, that could cut both ways. So either the applicant's a well-known gang member in the area where you're trying to send them, or the applicant's at risk in that area from gang violence, for example. So the information that you might get back may not be solely referable to the landlord or the property, but might be to do with the applicant, or might be to do with any number of different things. And then, as I say, the information, although it's important for the local authority, it's important for the applicant as well, because if the applicant comes to know that information, it will inform the applicant's choice as to whether or not to accept or refuse the offer. And it could justify the applicant's refusal of the offer.
Yeah.
Because the applicant at the time of the offer is likely to know probably nothing about the accommodation. They might subsequently go and view it and learn something, but generally they're going to know very little or nothing. But information might subsequently come to light which would justify their refusal. So that's the first thing, suitability. Secondly, children, and that's the case of AM and Havering. I don't know if the court wants me to go there, but that's the case which highlights the importance of notification for the purpose of transferring children's services.
Yes.
Does the court want to look at AM?
If you would like to see it, of course.
So AM is at page 247. And AM was a case about a family being transferred from accommodation in the originating authority to accommodation in another authority. Page 247. And there was an argument about which authority had to provide children's services assistance. And there are 2 relevant bits in the judgment. The first is at page 252. And it's paragraph 3, Roman 6. And if I could just invite the court to read paragraph 3, Roman 6, page 252. So in this scenario, there is an obligation to respond. It's not an obligation in the Housing Act, it's an obligation under the Children's Act. And the other reference is at paragraph 48, which is on page 271. Again, if I just invite the court to read paragraph 48 on page 271.
Yes.
So I accept what the respondents say, that in relation to this, it's only really relevant if there's an acceptance of the offer, because if there's no acceptance of the offer, then they're not going to move. But of course, it informs suitability again, because if the notified authority turn around and say, oh, sorry, we don't have any school places available for your child at the moment, or we can't provide the sort of level of support that your child needs, then that will inform the suitability decision. So these categories overlap.
Can I just ask a practical question about
Yes.
that? Before the local authority makes its offer of an out area placement, do they not make all those inquiries anyway? Certainly when I've read reviews and offers and so on, I've seen it written, you know, and there is a place at X school straight into, that would take one bus, and there is an offer at Y school. Now that's information that they must have surely gleaned themselves before making the offer. That's not been dependent upon the service of a notice, has it? I'm speaking from ignorance, I think.
Yeah, I mean, my experience is they don't.
They don't what?
They don't generally make proper inquiries or any inquiries as the available.
So was I just lucky when in a case that I heard, the review dealt specifically with schooling and even down to local shops and so on?
No, the review might do. But
that's right, that's what I meant when I'd read the review.
Right. No, I accept the review. The original decision often doesn't. The original decision is often in very much the template form of we consider location and so on, and they say we consider it to be suitable.
But have they not made those inquiries?
Well, in my experience, generally not. But then
they only do that for the purposes of the review.
Yes, because on review, the applicant will then say, but how and where my children are going to go to school, and it's a long distance to the school, and if I keep them in their current school, they've got an hour and a half. As in this case, it's too far for them to travel to school. And then at that point, they look at the availability of school places.
All right, thank you.
And then the last of the three relevances is local connection. And the relevant section is 198, and that is in the authorities. 39. And there are two relevant bits, 2ZA and subsection 4. And under 2ZA, if the applicant has accepted a private rented sector offer within 2 years of the acceptance of that offer, then they have to go back to where they made their application originally to apply. And under subsection 4, if they've been placed out of area, then the prescribed period I understand is 5 years. So then within 5 years of the placement in the other area, at any time within that period of 5 years, they'd have to go back to the original authority and apply back there. They can't apply to the place where they've been placed. So I accept what the respondents say. It's useful because then the notified authority will know when someone moves into that area. And the usefulness might go further than that, because they might be able to say, well, actually, they've always lived in this area, they've always had a local connection here, or they've always had a local connection somewhere else, or because they might already know of the applicant. So there may be various local connection may be useful in various ways. Finally, in relation to relevance, I want to look at the case of HHJ, which is at tab 18, so it's page 388.
Tab 18, did you say?
Yeah, if my lord's working
Yeah.
tabs. Page 388. This was a case about a private rented sector offer.
Mm-hmm.
For private rented sector offers, the authority had to be satisfied as to various requirements which are set out in Article 3 of the 2012 Suitability Order. And this case was about how the authority satisfies itself as to those requirements and what information they need. And the relevant bit for our purposes is on pages 413, 414, paragraphs 70 to 73.
Paragraph 70.
70 to 73.
Just before we read it, what's the proposition that you get out of this?
So this is helpful for various points, including the jurisdiction point. So this is similar to the notification duty. It's something that the authority has to do before they offer,
Yeah.
and it's something that informs their decision on suitability and therefore informs their decision as to whether or not to offer accommodation.
Yeah.
And it's relevant also to the jurisdiction point. Because it informs suitability, it's a point that could be taken on a homelessness appeal.
Yes.
So in relation to this, in relation to paragraph 70, the court accepts Mr. Colville's central submission. They must be satisfied on the basis of evidence rather than assumption. So applying that across here, one can't assume that the accommodation's suitable or that the notified authority are not going to say anything in response. It must be a decision based on evidence rather than assumptions. One can't assume that if they're a reputable landlord, there's not necessarily going to be anything the matter with the accommodation. In relation to paragraph 71, it can't be right that the applicant for the accommodation to raise a red flag. This is the point I made earlier about at the time of the offer, the applicant's going to know probably nothing. And so it's an obligation that falls squarely on the authority to obtain the information. As it said at letter G, it would be contrary to the scheme of the Act to shift the burden onto the prospective tenant to object, particularly since a failure to accept the PRSO has potentially drastic adverse consequences if the objection is not upheld. And then paragraph 72, again, repeating the point that it must be based on evidence rather than assumptions. So just in conclusion on ground one, we say it's not a burdensome obligation. I mean, it's simply to send at the same time or before you make your offer, you send a notification, in this case to Hillingdon, but to wherever you're going to send the person. And information may well come back which is highly relevant to the issue of suitability. But if you don't do that, you're missing a piece of the jigsaw. You're missing potentially very useful information. And really, it's for those reasons that we say that the breach in this case fatally undermines the decision by the authority that the property was suitable, because they couldn't make that decision in the absence of having the complete picture. So those are our submissions on ground one.
Thank you, Mr. Van Heegen. Yes, Ms. Screech-Powell.
Good morning, Your Lordships. If Your Lordships have no objection, Your Lord Lordships, I was going to deal with the jurisdiction point first, just because some of the points I say about jurisdiction and what is the purpose of section 2082 to 4 feeds into why we say it's got absolutely nothing to do with suitability, and that's why it can't be raised in section 204 appeal.
Take the points in whatever order you think fit.
Thank you, I'm grateful. So the starting point is section 202 of the Act itself, which sets out the matters which are subject to review. Here, the review sought was in relation to suitability because duty being discharged. That clearly does fall within the right to review. It doesn't include a right to review against any decision or giving or not giving a notice under section 284. So that, I say, is the starting point. And, you know, the list in section 202 is a comprehensive one. It's in the authorities bundle, if it helps me turn to it now. You'll see it at page 54.
Yeah.
So obviously the glaring omission from that list is any notice in relation to section 208(4) of the Act. And in my submission, there's actually nothing extraordinary about some notices having a right to review and others not. There are other examples where applicants don't have a right to review. One of those is section well, the examples where there are a notice is, for instance, section 202 1BB, which is any decision where an applicant isn't cooperating. So in those circumstances, you do have a right to review. There's also a right to review in relation to a decision to refer to another local authority, that's section 202(1)(c). So in other words, those notices where there's a local connection referral, there is a separate right to review. So it clearly falls within a county court's jurisdiction. The reason I highlight that to you is I do say these illustrate examples where Parliament has decided there ought to be a review right in relation to notices. It's made that specific provision in section 202. It hasn't made that provision in section 208 2 and 4.
Does that matter? I mean, if we know, do we not, that contrary to my misgivings, it is open to an applicant to say that the process of contracting out functions under the Homelessness Code is unlawful, even though there's no right to a review in the Act about that, but it's a potential ground of challenge to a decision for which there is a right of review.
That's right, but the distinction I say there, so I believe your Lordship's referring to the case of James v. Hartsmith.
Yes.
So that was a case where the actual review decision itself was arguably ultra-virus because the contracting out procedure hadn't been followed. In other words, the whole review decision would be a nullity, would be ultra-virus, which is a point that one can take in an administrative court as a point of law. I do say that's a distinction. I say the failure to serve a section 208(4) notice doesn't mean that the offer is in any way invalid. And I get that from what section 1935 of the Act provides in relation to what must be provided, which I think your Lordship's already referred
Yes, indeed. I see that. I'm just querying whether section 202 really brings much to the party.
The reason I'm going to ask you to look at it and to give guidance on this is the point I make is it must be any point of law arising from the decision. And there won't be any dispute about that. It must be something arising from the decision. What the appellant seeks to argue is that the failure to send a notice at the point of offer, so in other words the offer letter, is a point of law arising from the review decision. But I say that's not, because it's not the offer that's the subject to the County Court appeal, it's the review decision that's the subject to the County Court appeal. There is some authority that assists me on that point, my Lord, and it's the case of Adetsu against Lewisham and London Borough of Council, which is at tab 13 of the bundle.
Yes, I remember that. That's one of the ones that says that this appeal is not judicial review.
which I think, or with my submission, is what helps my construction of section 282, is at page 312, paragraphs 27 to 29.
Is it? It's the review decision, not the original decision.
That's right. That's the point I make there. So my first point, and I will move on to address you on whether it's got anything to do with suitability, and my submission is it doesn't. But if Parliament had intended this point about section 284, which is when you finally give a notice to be reviewable, it would have included it. And there are other examples of decisions that aren't reviewable. The decision as to whether there's a duty to provide interim accommodation does not fall within the County Court's jurisdiction under section 204. The contents of the local authority's assessment of an applicant's case under section 1891 to 3 are not reviewable decisions. The reasonable step that an applicant is to take in accordance with his or her housing plan under section 1894 to subsections 4 to 6 is not a reviewable decision. A decision that section 188 accommodation, interim accommodation pending review is not a reviewable decision. And a decision not to make a local connection referral is not a reviewable decision. And the reason I say that is significant is because not every breach of duty is going to have any relevance at all to review decision. One of the examples I've given is section 211 of the Act. And that's a duty to protect property of an applicant.
Sorry, which section?
Section 211. So it appears at page 70 of the authorities bundle. So there, that imposes a duty again on a local authority, but it cannot be right that if there was a breach of that duty, that would be something that would arise, a matter arising from the review decision, because otherwise you'd have applicants arguing, the risk is to have applicants arguing, well, you didn't take reasonable steps to keep my garden fork safe, therefore you're in breach of my duty, therefore I've got a right to appeal against your decision. It just doesn't relate or concern to the review decision. And I say the same about the appellant's point about section 208 notice and what its purpose is. Because to succeed in this appeal, the appellant does have to he does have to argue that it falls within a suitability assessment, and that's why I say the argument comes unstuck.
Well, I think Mr. Van Heegen accepts that. I think he says that if it's not part of suitability, then I think he accepted that it would be proper grounds for a judicial review rather than an appeal.
So what I say in relation to that is, first of all, the starting position is, well, what is the point of section 2082 to 4? So if I can ask your lords and ladyships to go back to section 2084, section 2082. First thing is, what does the notice actually have to give? Well, point 1, it gives the name of the applicant. The next point is the number and description of other people who might ordinarily reside with the applicant. Pausing there, you'll see my lords, that it has nothing to do with the names of the other applicants or even their date of birth. It's just the number and description of other persons. And in a way that answers one of the points about gang-related violence. Plainly, it's nothing to do with that. It says the address of the accommodation. Pause on that point. I think that's already been picked up on. It doesn't say anything at all about the landlord's identity, which answers another of the appellant's arguments that it's somehow related to inquiries in relation to the landlord and whether it's a fit and proper person. There's no.
Well, sorry, just pausing at 3B. What does description mean?
3B,
It obviously doesn't mean that they're 5'8" and got brown hair.
A child of 11, I should think, is
Yes, I think that's
a
fair
minor
comment.
and
Yes,
not a
yes.
adult child at university, something like that.
3 adults, 5 children, that kind of thing. I would wholly agree with that, yes. But what it doesn't do is say who are the names of, say, the other adults. So one of the examples was given is, well, what if there's gang-related violence that's relevant to suitability? But actually, this notice won't reveal anything at all about that. There's no requirement to identify the identity of the landlord. So in other words, it can't be relevant anyway to inquiries about the landlord because that's not one of the things that have to be notified in that. What I do say is significant in relation to what is the purpose of section 208 is section 208E, which function under this part the local authority was discharging and securing that the accommodation is available for his occupation. And so I do say that's clearly the primary purpose of this is directed towards the local connection provisions.
Just unpack that, just explain that.
The reason why that's significant is because the notified authority must be notified under what obligation, which housing obligation, the applicant is being placed in their district. And if they weren't made aware of that, there's always a possibility that an applicant could be owed a duty by one authority, perhaps even under section 188, be placed in another authority's borough, and then that accommodation ends or nothing further is done, but the authority that still owes the duty isn't actually providing for the applicant. So then the applicant goes to the local authority in whose district he or she is being placed and says, hang on a minute, I want you to help. But actually the obligation fell on the local authority to whom the application was made. So what this Act does is it creates a system whereby if an applicant is owed housing duties and is placed in another local authority's district, that local authority doesn't then fall under the housing obligation.
So I may be not being very bright about this, but
I might not express myself very clearly.
So going back from what I was asking about E, so the sort of information they'd want is whether or not it's a 2-year stay, a 5-year stay, if the obligation reverts. Is that the sort of
and
thing?
under what duty your accommodation was made available?
Yep,
Was it made
so-
under section 188?
Right.
Or was it discharged the main duty? Or is it a temporary offer in discharge of section 1935 so that the authority who placed the applicant still remains under a duty to accommodate?
Right.
And the reason...
Or if it falls apart, they've got to make their fresh application back to the original.
Yes, they
It's
can
not
be
landing
referred-
on them.
Absolutely.
That was what I was.
I'm sorry, I probably expressed it in a very
No,
long-winded way.
I've got there.
And the reason why I say you can see that is significant is if you look at the rest of the Act, so section 198, which appears at page 39 of the bundle, which is exactly the point your lady was making.
Sorry, give me the page again.
At page 39 of the bundle.
39.
So it's section 198, subsection 1. If an application is made to a local authority, but they consider the conditions for referral are met, they may notify the other authority of that opinion. So in other words, supposing an applicant is placed in someone else's borough in consequence of this local authority's decision to place them there, the local authority who receives them can then refer them back to Ealing.
Right.
So that's why I say that is a primary purpose of
So on the assumption that Ms Abdikadir had accepted the accommodation, but then for whatever reason it turned sour, she would apply to Hillingdon for help. Hillingdon would say, oh, but you came from Ealing.
Yes.
We're referring you back to Ealing because you've got a local connection.
Yes. Yes. That's what I say is the primary purpose. And I have some support from that, which appears in the bundle, which is odd on the homes and occasions. It's at the very back of the bundle, at page 486, paragraph 10166.
Yeah.
So that's why I say it's primary purpose, nothing to do with suitability. Now you have, of course,
Does the footnote help, which we haven't got?
it doesn't take it any further. If there was anything helpful or unhelpful, we would have obviously included it. Now, the appellant has taken to the case of R and AM against Havering, which they say is also relevant. And I can see that actually, in conjunction with the local authority's duties under section 213A, in terms of cooperation of cases involving children, I can see actually that is also another helpful purpose to it. I don't accept it's its main purpose at all, but I can see it's helpful.
What does 213A say?
So 213A is I'm sorry, my lord, it's not the bundle, but it's the duty on local authorities to cooperate with each other and with social services in cases involving children. So in other words, if a person's about to be made homeless physically because no duty is owed, the local authority are required to seek consent of the applicant to make a referral to social services.
Yeah.
So I can see how, and that's what happened in Havering. But Havering was quite distinct facts. This was a case where the applicant had applied to Tower Hamlets as homeless. Inquiries were made into her application. Social services then commenced a Child Act assessment, and there were very vulnerable children in that case. Social services accepted or started to assess. Tower Hamlets then placed outside of Borough into Havering, and Havering refused to carry out any assessment because they said, well, hang on a minute, Tower Hamlets are already doing it. Tower Hamlets' point was, well, so what, she's placed there now. And in the meantime, you've got this poor family with these poor children being pushed from pillar to post and nobody assessing them. And I'm not a family law practitioner, but I'm aware from sort of reading the judgment from colleagues in chambers that social services, if there's children involved, they have to move quite quickly. It's one day. So I can see in that context, when an applicant is going to be placed in borough, in another person's borough, I can see how that would be useful. But the point I would make on the AM and Havering case, which I see actually helps my construction of section 2082 and why it's there, is it refers to an applicant being placed in the other borough. So in other words, they're going to be physically there.
Yeah, in fact, section 213A is quoted in AM at page 260 in our bundle. So let me just read it. quite sure how this one works. Looking at subsection 2, local housing authority make arrangements for ensuring that where this section applies, applicants invited to consent to the referral of the essential facts of his case to the social services authority for the district of the housing authority, where that is a different authority. I don't know quite what that means.
I think, my Lord, and I might be wrong on this, but I think section 2 is when if someone is, it's not the responsibility of the local authority in whose borough the person is placed, and section 3 moves on to when it's the same local authority being responsible.
Well, and I don't understand what the words "to the social services authority for the district of the housing authority."
Where it's a different authority.
The new authority.
I see.
That's my interpretation.
Right.
So you have, one is the global intention, where you've got intentionally homeless and there's a child under 18. Subsection 2 is if you're shipping them out to a different local authority, it's getting the permission to provide the information to the other local authority. Section 3 is if it's intentionally homeless, under 18, but it's all within the same authority.
Yes, that's my reading.
All right.
So I've addressed the court on what I say is the real primary purpose of section 208, 2 to 4. I now address the appellant's arguments, which is why he says it feeds into suitability and is relevant. So first of all, I say no, that's not his purpose.
I'm sorry to be slow about this. If section 213A requires the housing authority to make the social services authority aware of the facts, then why does section 208 duplicate the duty? It's already there in section 213A.
Well, that's why I say section 208 isn't really designed at that. It is for local connection.
Right.
I mean, the way it was dealt with.
But also, 213 is all about when people are intentionally homeless. Whereas 208 is, you would say, providing information
when the duty's been accepted.
Well, then the duty's been accepted.
Yeah. So first of all, primary purpose of 208, 2 and 4 is local connection. The second point I make in relation to the argument that it somehow feeds into suitability is actually the duty to make inquiries is on the applicant, is on the local authority to whom the application has been made. The duty doesn't lie on the notified authority. They're not required to make any inquiries at all. The duty is on the local authority to whom the application has been made.
And so therefore you're saying notification, yes, but that doesn't require the local authority who've been notified to rush around and do all sorts of inquiries and send back information to the first authority.
No, and in fact it would be duplication of resources to do that, because the obligation is on the local authority to whom the application has been made to be satisfied as to suitability. It's not for another local authority to be satisfied as to that. So I say,
yeah, and there isn't a further subsection or a requirement that in the event that the offer is refused, local authority A will inform the out-of-borough authority, so they'll stop scurrying around and finding out where the gangs are and whether the landlord is shifting.
Third reason why I say the appellant's construction is wrong, it's got anything to do with suitability, is the point you just made. No obligation to do anything in response. And actually you can contrast that with the local connection referral provisions, because if a local authority does make a local connection referral, there is requirement then for the other local authority to respond. And that's section 1985 of the Housing Act. The appellant also argues that the reason it's relevant to suitability, the notice requirement, is that it means the notified authority can provide information about the landlord. Well, we've already gone through the section there's no obligation to give any information about the landlord, so that can't be relevant. The appellant also argues it's somehow relevant in relation to an evidence gathering exercise, and the points he relies on are the health and hazard rating system, and also the point about the fit and proper landlord. So the health and hazard rating system actually came into force long after Section 208 was in force, so that doesn't help the construction of Section 208. And also the point about the fit and proper landlord, that was introduced in the 2012 suitability order. So in other words, long after Section 208 had been in force. Section 208 has been in force since 1996. So I say that doesn't assist in terms of the construction of Section 208 2 to 4 and what it does. The appellant also relies on paragraph 17.22 of the Code of Guidance. The first point I make in relation to that is, well, that's relevant because that's in relation to private rented sector offers. This wasn't. This was a temporary accommodation offer, a private sector lease. It wasn't in discharge of final duties. It was a temporary offer, so in other words, Ealing still owed the duty. Had it been accepted, it would have an ongoing duty to keep suitability under review. In context with that argument, the appellant also relies on the case of HHJ against Westminster. Again, I'll make the same point, well, that relates to PRSOs, it doesn't relate to temporary offers. But actually, I say that assists the respondent's construction more so than it does the appellant's, because, of course, a local authority cannot approve a PRSO until it's satisfied it's suitable. So in other words, that comes first. It comes before the offer is made. A local authority can't make a PRSO offer unless it's satisfied it's suitable. That's section 1937F. It prohibits a local authority from making the offer in the first place. So those requirements have to be satisfied before the offer is made. So all those inquiries into fit and proper landlord, had this been a PRSO, which is not, but those have had to be made before the offer, those inquiries have had to be made before the offer was made.
Doesn't that apply to every case? I mean, surely a local authority will only make an offer, can only make an offer, in whichever way it chooses to discharge its duty, if it's satisfied that the accommodation is suitable.
Yes, and that's exactly the point I would make. You make those inquiries before you make the offer, because you're not performing your duty to secure accommodation is suitable until you've satisfied yourself it's suitable, you made the offer. And to pick up one of your ladyship's questions earlier, well, when is it satisfied? Is it satisfied at the date of the review? No, it's not. That's just not right. It's satisfied as at the date of offer, because that's how it performs its duty. It makes suitable accommodation available. And I do say you can see that actually quite clearly on the facts of this case.
Well, it may be different if the offer is accepted or refused.
And I'll come to that as well, my lord. So that's a very good point. If it's accepted, there might be an ongoing duty, and I'll address that shortly. But looking at the facts of this case, in fact, the appellant's housing needs had been assessed before the offer was made, and you can see that. First of all, you can see it from the individual inquiries made in this case in the supplemental bundle.
Yep.
At page 2. It gives various information about the appellant, but if I can just take you really to what's relevant for the purposes of this case and how the argument is developed at page 10.
Page 10, yeah.
It deals with any information in relation to health, in relation to any household member, in other words, the applicant and her children, all in good health. And then moving down, no allocated social worker, no child at risk, no probation officer.
So what looks like striking through
Yes,
are
it
in
does.
fact ticks, are they?
I think
I
on the
thought
facts
it
of
was
this
yes,
case,
yes,
we can
yes.
safely assume it is a no because we know there are no Child Act issues in this case, and that's not
Well, there are no details given either. So
No.
on the dotted lines.
No.
So
Perhaps it could have been filled in a bit more helpfully for someone like me when they come to argue the case, but we know from the facts Child Act issues were not relevant here. And you see that over the page again.
Yeah.
So in other words, these are inquiries that are done at the date of application in 2016, so inquiries are being made. Also relevant to this is the temporary allocation accommodation policy, which is found at the supplemental bundle at page 81.
81.
That's right, my lord, yes.
Yes.
And so I can just take you to page 83 of that. It's the second paragraph down, beginning all households that the council place in TA. And what it goes on to do is describe how the council assesses, and you see it assesses key elements of a household will be considered, which includes, but not limited to, location of employment, schooling, support networks, medical conditions, medical treatments, including frequency, access to local communities, social services. In other words, all these inquiries are done before a local authority is satisfied that an offer of accommodation is suitable. So that's why I say the appellant's point is wholly unrelated to suitability.
Yeah.
And I know this court will be familiar with the case of Zola Mesa against Westminster, which is one of the leading cases on sort of out-of-borough placements. And what the court advised is, you know, you do make these inquiries before you make the offer. You have to be satisfied an offer is suitable, or you're not securing your duty, you're not performing your duty to make suitable accommodation available. And what Lady Justice Hale suggested was one of the ways an authority can evidence how it goes about doing this is a policy. So I say this policy is also further evidence of how a local authority assesses, or how this authority is assessing applications, so to be satisfied as to suitability before it makes the offer.
Yeah.
And in fact, I say that the appellant's construction of section 208 cannot be right, because actually it just leads to absurdity. What the appellant argues is that the duty to serve the notice arises at the time the property is offered. So that's when the duty arises. As soon as the property is offered, the
Well,
duty...
I think Mr. Van Heegen is at least flirting with the idea that it arises before the property is offered, because he says the local authority can't be satisfied that it's suitable and therefore fit to offer, if I can use that phrase, until the Section 208 process has been conducted.
Well, I just say, A, with the greatest respect, I say that cannot be right, and it also would do enormous damage to actually to the scheme and how resources are allocated. And I say that for a number of reasons. First of all, if an authority is required to notify another authority that it's thinking about making an offer, or it does make an offer, and give them information about the applicant and who is there, first of all, what is the notified authority meant to do with that information? Does it then start to have to think, oh, hang on, alarm bells, Child Act duties, even though the family might never live there? Do they start having to get resources in place to start carrying out those assessments? Do they have to allocate a social worker? Do they have to start earmarking social workers? It can't be right. And actually, the facts of this case are really a case in point, because here, the appellant was made the offer on the 21st of July. She refused it on the 22nd of July. And she was notified that duty had ceased on the 23rd of July. But on the appellant's case, this authority would still have to notify the other authority within 14 days from either property being earmarked or being made available. I mean, that's also another problem, I mean, in terms of when the duty arises, but they would have to notify another local authority of an applicant and details of a household and of the address for a property in circumstances where they know full well the applicant isn't going to be there because he or she has refused the property. It doesn't make sense. And actually, I say it's a recipe for disaster, really. You know, receiving a local authority are thinking, oh, is this person here? Do we owe them a duty or not? Are they coming? Are they not? It would just cause an administrative nightmare. Now, what the appellant argues is, well, it's not really an onerous duty, just sending the notice. And perhaps in one case, in an individual case, maybe it wouldn't be. But if you actually break it down, in every single case, if an officer is having to send these notices, even though an applicant might not accept or might refuse, supposing they can send that email in, say, 2 minutes, it takes 2 minutes to fill in a form, put the name of the applicant and the address, that takes 2 minutes, that one officer 2 minutes. That's got to go into someone else's inbox, they have to look at it. That's what, another 2 minutes. Maybe that's not much in respect to one applicant, but for all the applicants in a borough, in one local authority, you can start measuring that in terms of hours. That's man hours, which we'd better spent looking for accommodation for people. If you follow it through to its logical conclusion, it's not just this local authority, it's all the London authorities and all the local authorities around the country having to send notices which don't go anywhere because an applicant might not be placed there. So I say actually it's a pretty big administrative burden. And we all know how we feel when we receive an email that's totally irrelevant to us. It's irritating. So what's a officer of another local authority going to do when they get this information? Well, are they coming or not? Do I have to phone up the authority and find out if they're actually coming? That's another few minutes wasted. Times that by all the applicants. It's a big burden, I would say, and it just can't be right. So,
you've got to tie that into the words of Section 208.
I do, and that's what
I mean, this part of the Housing Act is not there to avoid irritation to housing officers.
Well, this is why I say our construction should be preferred by tying it into Section 208. So if I can ask you to go back to 208.
Yes.
So what I say about sections 208.2 to 208.4 is they contemplate a process. And section 208.4, which is when the duty to actually give a notice arises, marks the very end of that process. Because what it says is, notice, as this is section 208.4, notice must be writing and must be given before the end of the period of 14 days, beginning with the date on which the accommodation was made available. So in other words, it contemplates the local authority, having been through all the steps, it's made an offer, it's made it available, an applicant has accepted it was made physically available. And I say that's actually consistent with not only how the Code of Guidance itself actually construes this provision, because if you look at paragraph, the Code of Guidance itself, at page, find it, it's 17, page 60.
Page 60.
7, sorry, which page? Give me 1 moment.
208 is 1760, page 95, where a local authority places an applicant in accommodation.
So in other words, I say the Code of Guidance is also contemplating an applicant having accepted the offer and being placed.
So how do you get that within section 208.4? You say that at the time of the offer, the accommodation is available in the sense that the applicant can either accept it or refuse it.
That's right.
But if the applicant refuses it, then the authority has not made it available. Is that the way you put it?
What I say is, Section 198 duty, sorry, the Section 193 duty, is again, it contemplates a process. You perform the duty by making accommodation available. So in other words, if you're making accommodation available, you are performing your duty.
And making available at that stage means here is a property, it is empty, it is suitable for you, you can move in if you choose to.
That's right, so you're performing your duty.
Right.
You're performing your duty. The very last dot in this process, and it has to be seen as a process, is physical rights of occupation are granted. So in other words, a tenancy agreement has been accepted and the applicant can move in. And I say there's nothing inconsistent or ludicrous about that, because of course the local authority can't simply perform its duty by saying here's an offer of accommodation, done, you know, and never granting them rights of occupation. It must contemplate rights of occupation being granted. That's the final full stop in the process. So you are performing your duty. There's nothing inconsistent about anything in relation to Section 175 or intentionality homelessness. We say our construction is consistent with that. You're performing a duty, you're making it available. You're not in breach of your Section 193 duty because here is a property, this is available, would you like to accept it? The very end of that process is the applicant says yes and signs the dotted line or accepts the offer, and then the property was made available for the purposes of Section 208.
So was made available carries with it the inference that the applicant has accepted the offer of accommodation which at the date of the offer is available. And that, you say, is consistent with paragraph 1760 of the Code,
which contemplates someone actually being physically placed.
Yeah, and I suppose you would also say that if the offer is declined, then there's very little point in the Section 208 full notification, whereas if it's accepted, then there is some point in it.
It should be done.
You may argue about what the point is, but there is some point in it.
Yes, yes. So I'm not saying it's redundant. It serves a point when an applicant is placed because it then facilitates the local connection provisions working.
And one finds was made available also in Section 208, subsection 3D,
Yes.
and so one doesn't need to make the notification until the offer has been accepted.
Yes. So that's a trigger point. We say notice doesn't arise until actually an offer's been accepted.
Doesn't it mean giving different meanings, I think, to the phrase is available and was made available, which
I say it
are very
doesn't.
different meanings.
Yeah, yeah. I say it doesn't because I say the duty, you perform your duty by securing that suitable accommodation is available. So I say the local authority is performing its duty. It's performing, not performed, it's performing its duty by making the accommodation available, by making an offer. Once the offer has been accepted, it was made available. So it's the distinction at Section 208, 4 and 3, it was made available because rights of occupation have been granted. So it's not inconsistent, I say, with any of the statutory scheme. In fact, I say it's consistent with it. And you can see it, my lord, in other parts of the Act. I mean, for instance, intentional homelessness, a person becomes homeless intentionally, so that they become homeless from property that they had rights of occupation in relation to. You can only become homeless intentionally from a property if you actually had some kind of right to occupy it. And that can be, it doesn't have to be tenancy, it can be an implied right, it can be permission, but it is related to rights of occupation. So I say that's why that makes our construction of Section 208, 2 and 4 consistent with the statutory scheme.
But you have got is available in 208 sub 2, and date on which it was made available in 3D.
Yeah, but that I say still feeds back to my point about this being a process. It's contemplating a process in the same way that performing a duty can actually is part of a process. And really the point where rights of occupation are granted, in other words, here is the tenancy agreement for you to sign, that's really the full stop in the process.
But it's quite difficult, I think. In this case, did Ealing make the property in West Drayton Avenue available to Mrs Abdikadir on the date when they offered it to her?
Whitehorn Avenue, I think your lordship's referring to, which is
Avenue.
yeah. Yes, because she was invited to attend and to sign the tenancy agreement with the viewing, and she refused to do so.
So, going back to my Lady Justice Asplin's point about 2082, by making the offer, Ealing, sorry to put this in the past tense, but just grammatically so, it did secure that accommodation was available for Mrs Abdikadir on the date when it made the offer. And if it did, then a duty arises under 2082, and 2084 tells you the date by which you must comply with that duty. So if a duty is triggered because accommodation is available, i.e. whether or not it's accepted, it's surely just a function of grammar rather than substance that in subsection 4 it talks about the date on which it was made available.
In my submission...
it certainly contemplates that the notification is given after the offer. We can't go with you that far because the date is a past date.
Well, what I say in relation to that is the court is dealing with a system of welfare administration. In other words, things ought to be given a purposive construction. When the court is looking at how to construe it, it's against the background that this is actually a system that's concerned with housing the most needy, it's concerned with welfare, it's concerned with administration. So I do say the court is entitled, when construing this, to have that in mind. What is the Act trying to do? What is this section trying to achieve?
I understand that. I mean, I can see there are very, very good reasons as a matter of policy for saying, well, if the offer's turned down, then there's no need for the authority to notify. Maybe absolutely right. But we've got to find it in the words of the Act.
But I say you can by considering this as a process.
Right.
Not sort of pinpointing a particular thing, but what is the process? But,
yes.
But if you're against me on that point, I do say there's some authority for the proposition that actually if the appellant is right and we are changing what meaning of the word available to make something available, actually there is authority for the proposition that sometimes things can mean different things in different contexts. And the authority I cited for that, but I do say this is my fallback position, but the authority I cited for that is the case of Halle, which is, I don't need to take you to, because it's on an intentionality of homelessness point, but it's at tab 9, page 208. And the relevant paragraph I flagged up as paragraph 23. So far it's said by the appellant that what the respondent is seeking to do is import a different meaning into availability. Actually, I say that's authority for the proposition that actually sometimes things have to mean a different thing in a different context.
That's a 21.
Oh,
not
I'm sorry,
23.
21, that's my eyes. Thank you.
Yes.
The third point Ealing make in response to ground one is actually this is all academic. Although we did cite section 31A in the Supreme Court Act, we're not relying on that for the purpose of this appeal. The court doesn't need to decide that. We actually say you can decide it in Ealing's favour on the case of Ali and Ewan, which is the authority that my learned friend relies upon. And we say actually this does satisfy the test that actually the appellant had refused the offer. The outcome would have inevitably been the same in any event. Now, you've been taken to the case of Ali and Ewan on the court's powers and whether it isn't inevitable, but I do remind you again of the facts, I respect to remind you of the facts of that case. That was a case in which actually the court found there had been serious procedural irregularities in Ewan's approach, and they are quite serious. It had failed to carry out any medical inquiries as to whether an offer of accommodation was suitable in the first place. It hadn't made those questions. It had referred to its GP, but never disclosed that information to the appellant. But perhaps most significantly, it recorded in the review decision that social services had assessed the property and concluded it was suitable. Well, in fact, social services hadn't. They'd been looking at B&B accommodation. So that was the back.
Isn't your point a rather simpler one? The offer was made on the 21st of July. The duty to notify, even if you're wrong about only arises if accepted, doesn't arise until the offer is made, because you can't say it's then available. And indeed, we know from the internal note that that was the only property available on the day that the offer was made. The refusal came the next day, and the council's decision the day after that. So there was a 3-day period in which all the relevant events took place. If a duty to notify under section 208 had been triggered on the 21st of July, there was no breach of it by the time that the council made its decision.
Yes, that's probably a better way of putting it, my lord.
And therefore, even if on the 21st of July the council had given notice, which it didn't have to, the decision would have been the same, unless Hillingdon had come back within minutes with some devastating piece of information.
And that comes back to, well, supposing an applicant has accepted and does move in, is section 208 for relevant suitability, which is something your lordship raised earlier.
Well, it may or may not be. I can see that if there is an acceptance, so that one is looking at matters at the date of a review rather than the date of the decision that the duty has ceased, different considerations might arise. I'm not saying they do necessarily, but they might.
Well, if I may address you on that, seeing as I've asked the court to make, to find whether or not it does fall within the court's jurisdiction, I say it makes no difference because it's not part of the duty to make inquiries. It's for the local authority to make inquiries when they make the offer. It doesn't, in my respectful submission, it just doesn't add anything because if there are relevant inquiries that have to be made into, for instance, location, they should have been made anyway. That doesn't add anything to that. A local authority is going to be making those inquiries anyway. And of course, section 208.4 is passive, as on the local authority who receives the notice, because they're not required to do anything in response.
Yeah.
So that's why I say, actually, even if it's accepted, it wouldn't have made any difference. It doesn't make any difference either.
Yes.
Those are my submissions.
No, thank you.
Thank you very much. Yes, Mr. Hegan, Van Heegen, do you want to reply on this point?
Well, what I would prefer to do is deal with ground 2 and then reply at the same time, so I can have the benefit of the lunch and adjournment.
Oh, fine. Yeah.
I'm grateful.
So we're moving on now to
Ground 2.
that is to say, effectively, section 208.1.
Exactly. So can we turn that up first, please? It's page 67. We're looking at subsection 1, so that's the duty, so far as reasonably practicable, to secure that accommodation is available. So the two relevant phrases for the purposes of ground 2 are, so far as reasonably practicable, what does that impose on the respondents? And secure that accommodation is available. And in summary, our ground 2 is that the obligation in subsection 1 is that the respondent should have looked not just at their own temporary accommodation, but they should have looked at what private sector accommodation they had and what accommodation they had available under Part 6.
Sorry, say that again. They should have looked at.
There are 3 different types of accommodation. Their own temporary accommodation.
Yeah.
What was available in the private sector.
Yeah.
And what was available under their allocation scheme under Part 6.
Yeah.
Because accommodation means accommodation. It doesn't mean a type of accommodation or
Yes.
certain types of accommodation. There are 2 authorities which shed some light on subsection 1 and what it means. The first one is Nzelemesu, and the relevant bit of that is paragraph 19, which is on page 240 of the authorities.
Can you just help me on how this works in practice?
Yep.
Particularly in a case like this one, where no point is taken during the course of the review. I mean, your client solicitors never said to Ealing, well, you haven't looked hard enough. They made all sorts of points about why the particular property wasn't suitable, but they never said, go and have another look at stocks. So what is the local... So the review decision doesn't actually address the point because it was never raised. I mean, it does make a few general remarks about policies, application of the policy, availability of accommodation, but it doesn't say, oh, and we did this, we did that, we did the other thing. When, if ever, is the local authority going to get the chance to respond to the kind of allegation that you are now making, that it should have looked beyond its own temporary accommodation?
We'll look at the review decision, and in my submission it does deal with this point because it was a point before the reviewer, which is why it's dealt with in the review decision. So generally it will come up in the review process, and the representations will say, well, didn't you have anything else? Didn't you have anything closer or in your area?
And is that, and do we see that in the papers?
Yeah, in my submission we see that in the papers.
Well, I think you need to show it.
Yeah, I will. I'll take you to the review decision.
Right.
There's a bit of the review decision that deals with
I would like to see where you say it's made, the points made in the representation.
That's what I was asking.
But
although they said this property is a long way away, I don't think, from memory at any rate, that it was ever said to Ealing, you haven't looked hard enough.
I mean, I'll consider that, but I know it's in the review. I'll junior maybe. But our primary argument in relation to this is that this is a duty placed on the respondents, and they're the ones who have to do the search, and they know what's available to them. And so it's a sort of Hajjaz's point, is it's not for us to raise red flags because we don't know at the time of the offer what you've looked for.
Yes.
So if I could go back to Nzelemesu, page 240, paragraph 19. I just invite the court just to read the first few lines, just going over the page.
Yes.
So it's a strong duty. It's more than reasonableness. It's sort of reasonableness plus. And the second case I want to turn up is Begum. And if we start at page 98, I'm looking at the facts in the head note. So it was a homelessness application. And in November 98, the applicants were offered a 4-bedroom house at 315 Sherwood Road. And they requested a review of suitability of that. And the claim was a judicial review on the basis that the authority were not complying with their duty to provide suitable accommodation. And the relevant bit of the head note is the last paragraph, paragraph 4, and then we look at the judgment.
So that was a case where it wasn't that they were limiting themselves, if you like, geographically or within to what they were looking for. It was what they were limiting it by a class of person.
By a type of accommodation.
They didn't use their own housing stock, which was reserved to applicants on their housing register.
Exactly. So they've excluded, so I identified 3 different types of accommodation. They've excluded number 3. They've excluded the part 6, what was available on the housing register. And it's dealt with in the judgment at page 105 of the authorities bundle. And the relevant bit starts about the middle of the page, the paragraph that starts, however, the court must bear in mind. And what they say is that in this case, this is the third line, in this case the council cannot show that it's done all that it can, since it's adopted a policy which has disabled it from having all possible accommodation available. And then they refer to evidence from Mr. Williams, the homeless coordinator. And the second bit of his evidence, where it says he goes on to make the point that pressure is increasing. And then at the bottom of that sentence, at the bottom of that page, they say that the accommodation comes from leased accommodation. It cannot come from the respondent's housing stock, because they say it's restricted to permanent accommodation under Part 6. So this is paragraph 11. The temporary accommodation, therefore, is either leased directly by the respondent borough from private landlords, or it's leased by housing associations who manage the properties. So they only looked at type 2 accommodation. They didn't look at type 3. They don't seem to have looked at type 1 either. And what the court says about that is that that's to disregard section 207 subsection 1, which is really a predecessor to section 206, which we've seen, which sets out the various ways in which you can provide accommodation, i.e. you either provide your own or you provide it for someone else. Which makes it clear that Part 6 housing can be provided from the council's own housing stock, provided it's not for more than 2 years in any period of 3 years. Thus, the council has not made available all that could be made available, since it's apparently thought it was limited in the way Mr. Williams described. And they also didn't look at a borough, but that's not relevant here. So, in relation to these cases, we say that Nazella Messu shows that it's a high duty, it's more than reasonableness. Begum's actually decided just on the basis of a reasonableness duty, but the current Section 2A, subsection 1 puts it higher. And Begum tells us that it's all types of accommodation. You can't restrict your accommodation. So it gives us a clue as to what accommodation means in subsection 1.
Yeah.
So if we now look at the review decision, which is in the core bundle, the relevant bit is on page 77 of the core bundle. And it's paragraph, well, it's really 29 to 31, but 31 is the key paragraph.
29 to 31.
Yes, but 31 is the one where they say we only had 10 whiteboard available.
I'm so sorry, I must be in the wrong place. 77 of the core bundle.
Correct.
And then you're referring to numbers.
Yeah. So I don't know. But there should be paragraph numbers on the paragraphs in the review decision. It may be that my lady doesn't have those because they were.
I don't, for some strange reason.
No.
Anyway, tell me where I'm looking on that page.
So it's the paragraph that starts as stated wherever possible.
Yes, thank you.
Yeah, and if my lady could just read that paragraph and the next two up to the heading size.
Thank you.
Well, we start doing at paragraph 10 on page 74. Where they refer in terms in section 2081 to number the section, but they're very well aware that that's their duty.
Yeah. Now I accept that they're aware of their duty. Ground 2 is you just didn't perform that duty in this, on the facts of this case.
Yeah.
So we're left with the assertion in the review that 10 Whitehall was the only available suitable accommodation. Then in the context of the appeal below, evidence was adduced in relation to that. And the judgment of His Honour Judge Saggerson starts at page 34. And the relevant bit, well, the two relevant bits, but the first is on page 41. It's paragraph 46.
So that's right, is it? The local authority did look for Part 6 accommodation. That seems to be common ground.
They looked afterwards. We're going to look now at the documentation. They looked afterwards for Part 6, found there was nothing available.
Well, the judge says at the material time.
We'll see now from the documentation. Right. It's obvious from the documentation, indeed, common ground. So we'll look at the documentation. That they look for Part 6, and there's a dearth of evidence regarding the private sector. And then going over the page, paragraph 48, he states that the appellant's nominally within paragraph 5 of Annex 1. That's important because if she comes within paragraph 5 of Annex 1, then she should prima facie be given accommodation in borough. And we can see that policy at the end of the review decision. So if the court looks at page 88, so this is Annex 1, extract from the temporary accommodation placement policy. The following households will be prioritised for placement in Zone 1. and then 5 is where you're effectively where you're in employment in the borough.
Yeah, but the last sentence says that you're expected to commute 60 minutes, and the review officer found that your client's commute was 40 minutes, so she's not within paragraph 5.
So that's why it said nominally,
Yeah.
because she fulfills the criteria of employment, but she didn't in fact because it was 40 minutes.
Yes. Paragraph 5 is not brilliantly drafted, because one would have expected to say, except in cases where...
Well, but that's taken care of by the rubric at the top. You'll prioritise for placement in Zone 1 where only accommodation needing would be suitable. And paragraph 5 tells you that it is suitable if you're commuting 60 minutes. And your client wasn't. So
Yeah.
she's not within paragraph 5.
Well,
And indeed, that the conclusion that she wasn't within Zone 1 was never challenged during the course of the review. It was in the minded to find letter. Nobody said you're wrong about that.
I don't need this for the purposes of ground 2, but I'm just setting it out. I mean, it's difficult to envisage a situation where if you were working in borough, then you would be commuting for more than 60 minutes anyway. It seems to me that the 60 minutes must mean that it's out of borough, but as I say, we don't need it.
I don't know how big Ealing is.
So looking at the
How many buses there are?
Yeah, and how fast. Yeah, I agree. So looking at the documentation, we start in the supplementary bundle on page 21.
Yes.
So this is what's referred to in the review decision.
Yes.
So this is an email of, or something, of 24th of September 2020, where there's a call to Nana, and Nana says that 20 Whitehorn was the only 4-bedroom at the date she was offered accommodation. If one then turns to page 75 of the supplementary bundle, 76, sorry, these emails are in reverse order. We have to start at 76. There's an email sent on the 15th of July. And the second bit of the email says, please confirm what information your client relied upon for Mrs. Smart's email of the 24th of September 2020. That's the document we've just seen. Please also provide us the list of properties available under Part 6 on the 21st of July 2020. And then they chase on the 16th of July.
What's Mr. Smart's email?
So Mrs. Smart was involved in the review. I think we're told at the start of the review decision that she, paragraph 3 of the review decision, page 72, Ms. Smart has assisted with this review.
Oh, I see. Yeah.
So then the substantive response is at the bottom of page 75, going over to page 76 from the lawyer. So at the bottom of 75, they send a copy of Ms. Smart's email. Regarding properties available under Part 6, you'll be aware these properties are allocated under the allocation policy. As such, Part 6 accommodation was not considered by the reviewer when checking what accommodation was available at the date of the offer. And then on page 75, there's further chasing for a list of what's available. And eventually on page 79,
Sorry, so just hold on there. So this email says that Part 6 accommodation was not considered by the reviewer.
Exactly.
So the judge was wrong when he said that it's common ground that it was. Is that right?
So this is at the date of the offer. So subsequently, they did look at their part 6, which I'm going to take my lord's
Right.
So at page 79, we get the search being done by Nina Yusuf. So it's not Nana, it's Nina. She does a search on the 11th of August 21. So she ran a report on La Carta, shows no 4-bed property was available on that date, and then you can see her report on 79. And then going over the page, you can see that from her footer that Nina Yusuf is a housing demands manager from the allocations and applications team. So she deals with the Part 6 housing register, accommodation. She's done a search, shows that there was no Part 6. So they admit they didn't search for Part 6, but they say, well, none was available anyway. And then on page 79, Miss Smart writes to Respondent's lawyer and says, please see below email, no 4-bed was available on La Carta on the day they were offered accommodation. So our point in relation to ground 2 is you didn't search Part 6, but we accept that you did subsequently and there was nothing available, so it doesn't really get us home. But you didn't do anything at all in relation to your in relation to private sector. And if one looks at their acquisitions policy, which is the document which my lord gave permission for at the start of the hearing, one can see, so I don't know, does the bench have it? Because there was a further bundle, I think it was appended to the application.
I got it somewhere.
Yes, I've seen
I'm
it.
not quite sure what's.
It's not in the core and supplemental bundles, because it wasn't.
Yes, I think it's in this file. Yes, unagreed bundle.
Yes, that one.
Yeah.
So it starts at page 7 of the unagreed bundle. So it's the respondent's application. And
Is it the same or different? No. No, I'm sorry, it is different.
Yeah.
Yes.
There's an acquisitions policy
Yes.
and a placement policy.
Exactly.
Exactly. And it's at 7.
This
Thank
is
you.
the acquisitions policy.
Exactly.
Yeah.
So it starts on page 8. And paragraph 2 says that they've got a duty to provide temporary accommodation, which is what this is a 1935 temporary accommodation, for households that approach the council as homeless and who meet the eligibility criteria. Policy covers and then sets out what it covers. 1.8a, which isn't relevant. Provision of temporary accommodation under 193. And then the offer of private rented sector. So it covers this scenario, which was provision of temporary accommodation under 193. And then it sets out the policy aims. And the first of those policy aims is to acquire a sufficient number of units to meet property demand suitable to the needs of households. This will include TA and private rented sector accommodation to end a homelessness duty. So the way in which they discharge their 1932 duty is by acquiring temporary accommodation and private rented sector accommodation.
Yeah, and then we see at the bottom bullet point to work with private sector landlords and agents, etc.
Exactly. That's where I was going next.
Sorry.
No, very helpful.
Yeah.
And then there's, on page 11, there's a heading acquisitions activities. And on page 12, it sets out the various ways, 12 going on to 13, the various ways in which the council acts to acquire temporary accommodation and private sector accommodation in order to discharge its Part 7. And I would invite the court to read on page 13, there's a heading property location in the middle of the page.
Yeah.
Just the first paragraph of that, which again makes the point that they use private sector to meet TA demand.
Yes.
Sorry, can I just, going back to page 12, the second paragraph, that seems to be identifying how they're going to recruit private landlords.
Exactly. One of the ways, again, private sector. Yeah, and again, the fourth one, in-house PSL service, a private sector letting service. They work with managing agents and suppliers.
So do most housing authorities have lists of approved private landlords then?
That's my understanding, because not all private landlords will take people who are homeless and dependent on benefits.
And simply, there's certain landlords that the housing officers would not choose to put.
Exactly. Yeah. And the local authorities have sold off a lot of their own accommodation, or it's been brought under right to buy. So because of the diminution in their stock, they have to rely on private sector. So this policy in my submission clearly sets out the way in which they're going to discharge their Part 7 is by heavy reliance on the private sector. And our point on to ground 2 is a simple one. You didn't do that in this case. All that the respondents appear to have done is checked their Locata system and found that Whitehorn, well, there was nothing available under that Locata system. So they appear to have got Whitehorn through their own temporary accommodation, but they don't appear to have looked. There's no evidence they looked at all at the private sector. And that's really the main source of accommodation now.
And Locata is their own stock.
Well, not necessarily, but Locata is their housing register, so it's all the accommodation that people on their housing register can bid for. And it may be their own stock, but they also have agreements with housing associations, nomination agreements where they can place people in housing associations or social landlord accommodation.
But it doesn't include their list of privately approved landlords.
No, this is separate. So
Right.
this
So it's housing association, it's social housing in one form or another, either by route of the housing association or their own very tiny stock these days.
Yes. But it seems from this policy that they also use some of the housing association stock as temporary accommodation.
Yeah.
If we go over to page 14 for a moment. I'm told they focus on zones 1 and 2. This is the penultimate paragraph. They liaise with accommodation providers and check relevant websites on a daily basis for new supply. Is there any evidence to suggest that that policy wasn't followed in this case?
Sorry, where's my lord reading from?
Second hole punch. The council's acquisition officers are instructed to focus on zone 1 and zone 2 areas first, etc., etc. Acquisitions officers liaise with accommodation providers and check relevant websites on a daily basis for new supply.
Yeah. So there's no evidence at all that they did that, and that's our ground too, because they were asked repeatedly, what did you do, what did you check, what list did you have available? And the only thing they came back with is, we looked at Locata, there was nothing available on Locata. So even today, there's no evidence from them that they did anything. They've shown subsequently that a search of their own stock under the Locata system would have been but they haven't shown that they searched their private sector landlord, managing agents, the people they've got deals with.
Yeah.
So that's our ground two. They didn't comply with subsection 1 because they didn't look for accommodation. They only looked at a certain type of accommodation, not accommodation generally, and therefore they didn't comply with the duty. And the duty is not a reasonableness duty, it's a reasonableness plus duty. So it requires them.
Would it satisfy the reasonableness plus duty for them to check simply amongst their approved landlords, or do they have to ring round all the local agencies and go online for people that aren't on their list? See if one of them might have something and might agree to have, or is that going beyond reasonable?
Well, for the purposes of this appeal, I only have to argue the former, and I'd only argue the former.
All right.
And crucially to your argument, you say that they didn't follow the policy insofar as it suggested that acquisitions officers would look at websites, relevant websites daily.
Exactly.
That might have been good enough, or it might not. We don't need to worry about that. But the fact is, they didn't do it.
Yeah. So if they complied with their policy, yes, I agree with my lord, that probably would have been good enough. But they didn't. I mean, that's the alphabet point, is that if you comply with your policy, then that's good enough. So yeah, that's our ground two.
Yeah. And to make that submission good, you rely on the various email exchanges that you've shown us, in which the council were interrogated about what they did and what they came back with once we looked at the Carter.
Yes, exactly. So they were asked repeatedly, what did you do? And that's what they came back with.
Right.
And they haven't sought to resolve from that.
All right. Thank you, Mr. Van Heegen. Well, do you want to start for 5 minutes now, Ms. Scoochpower, or would you rather start at 1 to 2?
I'm happy to start now in your lordship's hands.
All right, well, let's we might as well have whatever we've got, 5 or 6 minutes.
I might be able to get through a few preliminary points on ground 1, on ground 2 rather, so which might have time management. I mean, I would like to begin by addressing the court on 3 preliminary points before I actually get to the substance, if I may, which is first of all some preliminary points about the review process itself.
Sorry?
Some preliminary points about the review process itself.
Review process,
and what case was being put on review. Secondly, to address the court on the importance of guarding against judicialisation of the welfare services, and also of giving due accord to local authority policies. And then finally, I'll address the points about point 6 allocations and also private searches at the very end. So, dealing with the first point I make, the review process itself, my lord, you've been taken to a number of emails in the bundle, which the appellant says is evidence that they were pushing and making lots of inquiries about what other searches were being done. So if I take you back to page 75, that's where those emails appear of the supplemental bundle. Okay. The writing I know isn't terribly easy to see, but hopefully you can at least see the date, which starts really from 75 onwards, but it all postdates the review decision. The review decision was on the 5th of May 2020.
Sorry, which one are you looking at?
Well, if you look at the
Page 75 is where I am at the moment.
page 75. So if we look at the one dated 29th of July, which is the last one at page 75.
Yeah.
Whether or not the council looked at
That's
the
to Miss Khan.
That's right.
sent at 21:47. That one.
That's right.
Yeah.
The short point I make about that is that postdated the review decision. The review decision was on the 4th of May 2021. These were made on the 29th of July 21.
Yeah.
And so really the short point I make in relation to that is actually a review decision is dealing with the case that's put to it on review. That's the whole point about having representations. I've cited, the court's probably familiar with the case of Cramp and Hastings, where they said about the review process and the enforcer make inquiries. That puts the authority on notice. But the case I've actually cited, which I say is even more relevant here, is the case of Pally and Malvern Forest, which is at tab 20 of the bundle. The authority's bundle at page 464.
Well, if we're going on to an authority and 1 o'clock has just chimed, perhaps we could leave it there and come back to that one at 2 o'clock.
I hope I've given you some food for thought over lunch.
I see my ladies will be very familiar with this case. Right, 2 o'clock.
Court rise.